Good morning. My name is Doris Meissner, and I'm at the Migration Policy Institute, a senior fellow here. And I'd like to welcome everybody to this call, which we've entitled the U.S. Asylum System in Crisis, First Steps for Rescue. You all know we have a little competition this morning on issues of public interest, so I want to particularly thank you for calling in and participating in this. The slides and the audio from today's webinar will be available later on our website. If you have any technical problems, please email events@migrationpolicy.org or call 202-266-1929. We will have a Q&A during the latter portion of this call. There will not be a voice Q&A. So please type any questions that you have into the Q&A or chat box on the right side of your screen and send to the host or me or email to events@migrationpolicy.org. Or you can tweet your questions to @migrationpolicy or #MPIDiscuss. Let me briefly introduce our presenters. In addition to myself, we have Faye Hipsman, who's formerly a policy analyst here at MPI and now a law student at UC Berkeley. Alex Aleinikoff, who's formerly the United Nations Deputy High Commissioner for Refugees and now a professor and director of the Zolberg Institute on Migration and Mobility at the New School in New York. And finally, Eleanor Acer, Senior Director, Refugee Protection at Human Rights First. The report that we're releasing today and discussing now is on our website. It's called the U.S. Asylum System in Crisis, Charting a Way Forward. The co-authors are myself, Faye Hipsman, and Alex Aleinikoff. We're going to start by describing briefly to you the way the asylum system works and what some of the recent trends have been. And Faye Hipsman is going to be starting us off. Faye?
Good morning, everyone, and thanks for joining us on this most eventful morning. I plan to give an overview of the U.S. asylum system and how it works, describe some of our data findings, and explain kind of how we got to this point where the asylum system is so troubled. So to begin, to be granted asylum in the United States, one must demonstrate a well-founded fear of persecution based on race, religion, nationality, political opinion, or membership in a particular social group. And the asylum system is broken down into 3 different pathways. The first is the affirmative system, where individuals who are already in the United States can apply affirmatively by submitting an application to U.S. Citizenship and Immigration Services, which is in the Department of Homeland Security. And these applications are reviewed by asylum officers. Unsuccessful applicants are referred to the Executive Office for Immigration Review or the Immigration Courts, which is within the Department of Justice. And there, at that point, an immigration judge considers the case again. The second system is the defensive system, where people who are in removal proceedings because they were apprehended or issued a notice to appear can apply for asylum defensively as a defense to their removal. And this group includes the group I mentioned above, whose applications were not approved by USCIS. And the third pathway is for people who are seeking protection at a U.S. border, and they face a kind of hybrid system. Most migrants who are apprehended at the border don't have proper paperwork to enter the country, and a lot of them are subject to expedited removal, which is a quick form of deportation that involves no hearing or no immigration judge. Those who are placed in expedited removal and express a fear of return to their home countries are given a credible fear interview usually within several days, and this is done by an asylum officer. The asylum officer determines whether the person has a significant possibility of being eligible for asylum. And those who pass the credible fear interview are referred to the immigration courts, where they can then apply defensively. And I should also mention that unaccompanied children who arrive at the border are treated differently. Under a 2008 anti-trafficking law, children from countries other than Mexico and Canada are placed in immigration court proceedings, but if they do choose to apply for asylum, their cases are first reviewed by an asylum officer, USCIS, and if USCIS does not approve the case, the child can then reapply in immigration court before a judge. So I'll now move on to some slides and what the numbers tell us. So this first slide shows affirmative asylum cases filed with USCIS from 1993 to 2017. And essentially from the mid to late 90s, when the system I just described was formed, up until about several years ago, the system worked pretty well. But in 2010, affirmative applications to USCIS started to rise and have now reached near historic highs, as you can see from the chart. In 2010, about 28,000 applications were filed with USCIS, but that figure has risen to 143,000 in 2017. And part of this rise can really be attributed to an increase in asylum seekers who are unaccompanied children. In 2013, there were about 700 such applications, but in 2017, the number rose to 18,000. So this slide adds credible fear to the mix and shows that like affirmative applications, credible fear cases have also surged. Between 2010 and 2017, these cases rose from 9,000 to 79,000 and peaked at 94,000 in 2016. And this trend really reflects new regional dynamics and new humanitarian flows at the border. But procedurally, it has meant that USCIS has had to send about 40% of all of its asylum officers, about 520 of them, to conduct credible fear screening interviews. And this is staff that would otherwise be reviewing affirmative cases. So this chart really shows how the workload of USCIS has risen substantially in the last 5 to 7 years. The result of all of this is a huge affirmative backlog. It has essentially grown larger every year since 2010, and as of June 2018, the backlog was 320,000 cases. With a backlog this large, many asylum applicants wait 3 to 5 years just for an asylum interview. In our report, we'll lay out a few additional factors that have contributed to the rise in applications and the backlog, but the most important one of them is cancellation of removal. Cancellation is a form of relief available to non-citizens who don't have legal status but who have been in the country for 10 years or more and meet some other requirements. The issue is that cancellation can only be granted by an immigration judge, not by USCIS. So it's become common practice to apply for asylum just as a way to access the immigration courts and file an application for cancellation. And to kind of give a sense for the scale, USCIS says that about 40,000 cases in the backlog were filed 10 years or more after the applicant's arrival in the U.S., which indicates, although it doesn't mean for sure, that the person may be seeking cancellation and not actually asylum. And again, for USCIS, this has meant that a large additional caseload is on their plate that uses additional resources. So I'll now move on to the defensive system, where applications have also been rising. In 2010, the court received about 33,000 asylum applications, and in 2017, that number was 120,000. A key reason, again, has been the increase in credible fear cases, which are referred to the immigration courts. This has substantially increased the number of asylum applications that the courts have been receiving. This last chart shows that the backlog of total cases in immigration court, it now stands at a record 746,000. We estimate that about 30% of these cases are asylum claims. And the backlog in the immigration courts, like with the affirmative system, has created possible wait times of several years, up to 5 years. So when you put some of this data together, people who begin the asylum process affirmatively and their application is not approved and then have to go through the defensive process face a possible wait time or a process that start to finish is about 10 years. And this creates a lot of uncertainty in the lives of asylum seekers and their families, but also some of the misincentives that I described with cancellation. So I hope this overview of the numbers shows the crisis that the asylum system is facing and kind of how we got here. And just to add a couple of additional points, I want to stress the importance of regional migration dynamics and changing flows at the border in all of this. About 10 years ago, 1 out of every 100 border crossers was an unaccompanied child or a person seeking humanitarian protection, but today that share is 1 in 3. So it's a tremendous change. And this is really happening because of extreme insecurity in Central America. This includes gang violence and high murder rates, but also a high incidence of domestic and gender-based violence. And our report goes into much deeper detail about this and touches on some issues like the role of internal displacement, increases in asylum applications in countries like Mexico, Belize, Costa Rica, and Panama, and steps that the region has taken to address these challenges. So with that, I will turn it over back to Doris.
Okay, thank you so much, Faye. You've really laid out very fully what the nature of the crisis is, and we, I think, have to agree that this does represent a crisis, but there are all kinds of ways to respond to a crisis. And the ways that this administration has chosen to respond to the crisis are basically to try to deter the flows, primarily and most dramatically through its zero-tolerance policy that has led to separation of families, among other outcomes, and also by trying to narrow access to asylum and protection in the United States, again, by changing the rules of the game through the precedent decisions that the Attorney General has issued from the Board of Immigration Appeals and EOR, and the guidance that then flows from that to guide the decisions that immigration judges and asylum officers make. What we're doing in this report is putting forward an alternative path. We are putting forward a path that says that asylum system and the change, the crisis in the asylum system needs to be addressed by restoring timeliness and restoring fairness as the hallmarks of the system. The report draws heavily on the personal experiences that Alex and I had in the 1990s along these lines, and through that lens we've looked at the asylum system again in order to determine how timeliness and fairness can be restored, because they will in turn provide protection but also discourage unfounded claims. So let me go to the recommendations that we are making in order to get back to timeliness and to fairness. The recommendations that we're making are based on a deep dive that we've taken into the metrics that underpin the asylum system that Faye has described. We've looked carefully at the caseloads. We've looked carefully at the resources. We've also convened a number of intensive discussion sessions with senior officials in the government, with experts on asylum issues, with stakeholders, and included in that has been the United Nations High Commissioner for Refugees. We have concluded as a result of that analysis, which is all laid out in the report, that the opportune place to start in retooling the asylum system is the affirmative system. We have not taken on the entire system. It's too sprawling, but the affirmative system does lend itself to a series of measures which we believe could make an important difference. And we've chosen the affirmative system as the place to begin for a number of reasons. First of all, because a goodly number of things can be done in the near term. Secondly, because they can be done through administrative action. They don't require Congress and they don't require statutory changes. And thirdly, because some of them have begun already and should be strengthened. Finally, because they've been shown to work in the past. Our primary recommendation is in 4 parts, and it's focused in particular at restoring timeliness. The first part of the recommendation has to do with last in, first out processing of incoming cases. This actually has already begun. The USCIS has begun doing last in, first out processing in January. We're proposing that it be built out more fully, and we do believe that last in, first out is the best way to do a reset that gains control of the system by putting some greater rigor into the cases that are coming into the system newly so that they can be decided within 6 months and begin to put a new dynamic into place. We've done a detailed analysis of the numbers that it would take to do that, the staff, the budget, the caseloads, that's in the report. It is doable. The second part of our recommendation has to do with credible fear cases. And in this connection, we are urging that credible fear cases that are done by the asylum officers also be completed by asylum officers on the full merits adjudication rather than referred to immigration judges, as is the case at the present time. Here again, we've looked at the numbers. It is doable, and it has some very important advantages because it means that the initial fact-finding that's already been done simply can move forward and doesn't have to start all over again before immigration judges. The cases are fresh. They can be finished more readily, presumably within 6 months, and this uses both asylum officer and immigration judge resources to far better effect than is currently the case. One impact of this would be to reduce the caseloads that immigration judges face at the present time for the cases that are granted. Of course, those that would be denied by asylum officers would still have the opportunity for an appeal before an immigration judge. Thirdly, we are proposing ways to streamline the credible fear screening. I won't say anything further about that. And finally, we're going to the very important issue that Faye outlined that has to do with cancellation of removal. Cancellation of removal is a very important part right now of the affirmative caseload, but it is a workload that is misplaced within the asylum system. It represents probably about 20% of the affirmative asylum caseload, and what we are doing here in the report is suggesting a couple of options for how to handle those cancellation of removal cases differently. USCIS has begun a third kind of a pilot program, experimenting on different ways to deal with cancellation of removal. That is an area that really does need to be changed in order for the asylum system, the affirmative system, to get back onto a sound footing. So if you take these steps together, they would constitute a significant retooling. They would get the affirmative system back onto firm ground, which we think is the best way to jumpstart even broader reforms that go to the asylum system more fully. Those broader reforms, of course, certainly involve the immigration judge system, which is the heart of the defense of asylum system. That is a very big challenge. And then beyond that, there are the issues of the southwest border and southwest border enforcement practices, incorporating asylum much more fully into the way in which border enforcement is now being carried out because of the significant change in the flows that are taking place at the southwest border. And finally, of course, as Faye noted, there are issues of the underlying causes in the region and a far longer-term agenda that has to do with source countries, Guatemala, Honduras, and El Salvador in particular, and regional approaches to working cooperatively to reduce the need for asylum flows coming to the United States. So these are all solutions that need to work together. They are requiring a multi-pronged approach, significant interagency effort, and a very sustained long-term regional focus. But the report that we're giving you today, although it covers all these points, it also focuses in particular on fixing the affirmative system because it is, as I've said, what we believe to be the best starting place to rescue our asylum system today. With that, let me turn to Alex, and Alex is going to talk a bit about some of the legal issues that go to the substantive areas of concern about asylum today. Alex?
Thanks, Doris, and welcome to everybody. Happy to be here today. First, let me start by noting that there are a number of impacts on the number of cases that come before the U.S. System, conditions in the home country, major, of course, and then also the actions of other states, like deterrence policies they adopt, and as well as the asylum systems they have. So if countries in the region have asylum systems where people can file their claims and they needn't come to the U.S. to file asylum claims. And then there are other aspects of the U.S. system, as has already been described, the avenue for cancellation of removal. But what I want to focus on are the substantive standards for asylum, both from the U.S. domestic side and also from the international side. As Faye noted, Salvadorans, Guatemalans, and Hondurans are among the top nationalities that have been filing asylum claims in the U.S., and a large chunk of the increase that we saw in her charts. Many of those cases are cases alleging persecution by non-state actors that the state cannot control, either cases involving gang violence or domestic violence and other forms of violence. And so people flee north from those Central American countries and come to the United States seeking asylum. For many years in U.S. asylum law, there was an issue about whether people fleeing non-state actors could qualify for asylum. That was answered in the affirmative that they could, if they could show that the home state was either unable or unwilling to protect them from the kind of persecution that qualifies for relief for asylum, then they could state the asylum claim in the United States. So you had to show that you fit within one of the so-called 5 nexus grounds of race, religion, nationality, political opinion, or membership in a social group. But if you could establish that you're being persecuted on one of those grounds by a non-state actor that the home government could not prevent from harming you, then you could state an asylum claim in the United States. This was expanded several years ago by the Board of Immigration Appeals after a long set of cases and arguments by advocates to include women who were victims of domestic violence. This is a norm that's recognized in a number of other countries around the world. The U.S. was late getting there, but did recognize that those kinds of cases could be brought. Attorney General Sessions, just a few months ago, took the BIA case that established this norm and reversed it. And without really reversing the legal standard that applied, and I won't get into the technicalities, he nonetheless said that only in very rare cases should someone alleging domestic violence or gang violence, for that matter, be able to qualify for asylum in the United States. The impact of that on the problem we're describing here will actually be to reduce the number of cases that come to the asylum office if people choose not to apply because they think the Sessions decision means that they will not be able to get asylum. And since a number of cases come from the countries, a large chunk of cases come from the countries where people are making these kinds of claims, we might suspect that the numbers would go down. Now, in terms of getting ahead of the backlog and things, that is helpful towards that. But we're not happy with that result. We don't think that's the way to solve the system, is to change the standard here. And more importantly, it's not obvious that the Sessions decisions will in fact reduce the flow for 2 reasons. First of all, as I said, the actual standard didn't change, even though the Attorney General indicated that most of these cases shouldn't be granted. So you'll still have asylum officers and immigration judges who may well be sympathetic to these cases finding ways to grant asylum. And it's difficult for an asylum adjudicator, a judge, or an asylum officer faced with someone who they think is likely to be persecuted if returned home to order that person to go home. So you may still have cases granted. Moreover, the courts of appeals will be able to weigh in on the Sessions decision and decide whether they think it accords with international law and U.S. domestic law on asylum, whether it's a proper interpretation of U.S. law. Under international standards, which courts of appeals don't normally apply in U.S. law, but under international standards that UNHCR has played a significant role in helping bring about, it seems quite clear that the kinds of cases that the Sessions opinion casts great doubt on are recognized as, can be recognized as bona fide asylum cases. That is, non-state actor cases alleging domestic violence and gang violence, other forms of violence, generally, according to UNHCR, can qualify for asylum. So there's a conflict here between the international law and the Sessions statement. How the courts of appeals will go on this unclear. As I say, they tend not to follow international standards, and they also tend to defer to executive branch agencies charged with interpreting the law. So that may mean that the Sessions interpretation will stand, which may have a downward impact on the number of cases filed. One more point on the international standards here. International law is pretty clear. It says in the Refugee Convention that states are not allowed to impose penalties on asylum seekers. And it's pretty clear to us that the policies adopted at the southwest border by the Trump administration are in real tension with that norm of non-penalization of asylum seekers. The detention of children and families and the zero tolerance policy which gave rise to it seem to be penalties imposed on asylum seekers, particularly because they are done not simply to regulate a flow of people at the border, but they are done to deter, with the express purpose of deterring asylum seekers from getting to the United States. Now, whether we will see a court applying that international standard in the United States, that may be unlikely, but nonetheless, as a matter of international law, these are very problematic policies. I'll stop there. Thanks, Doris.
Okay, thank you. Thank you, Alex. Eleanor, we want to turn to you now, and I want to tell our listeners that up till now you've been hearing from those of us who have co-authored the report, so we have a strong belief that we're on the right track here. Eleanor is not a co-author of the report, but she's been very involved in the process. It actually was her idea a couple of years ago that we do this kind of a deep dive, and she's been at the meetings that we've held surrounding the discussion on these issues, and she also was a reviewer of the report. So, Eleanor, I'm so glad that you're willing to join us this morning, and would invite you to make whatever comments you might want to offer in the form of a critique of the report, and also help broaden us out to look at any other parts of the asylum system, particularly what's going on with immigration judges and case preparation as you see it on the ground, because you're so very close to the actual workings of the system and work with real applicants.
Thank you, Doris, and thank you also to Alex, Faye, and MPI for inviting me to join this discussion. Congratulations to all of you on issuing your report on the U.S. asylum system. Human Rights First is a U.S.-based human rights organization that encourages this country to provide leadership on human rights around the world and here at home. We have offices in Los Angeles, Houston, Washington, D.C., and New York, and in those offices we provide pro bono legal representation to refugees seeking protection through the U.S. asylum system, working in partnership with volunteer lawyers at many of the nation's leading law firms. Our pro bono clients have fled a wide array of countries where human rights violations run rampant, and we have many clients whose cases are or were pending before the USCIS Asylum Division, as well as the immigration courts. I want to flag as a preliminary matter a point that a number of you touched on, the importance of increasing protection and asylum access in countries across the region. The increase in U.S. asylum claims is part of a regional and global phenomena, with people regionally fleeing not only to the United States, but also to many other countries, including Mexico, Costa Rica, Panama, Colombia, Ecuador, and others. And they are fleeing not only from El Salvador, Guatemala, and Honduras, but also Venezuela, which is now the top affirmative asylum application country, I believe. And we will likely see numbers increasing from Nicaragua, given recent political violence there. The MPI report makes a number of important recommendations, and I'd like to reflect on a few of those. First, I'd like to flag one recommendation that may not otherwise get much attention in the report because it gets one sentence, but I think it's incredibly important. On page 26 in the discussion of the shift to the last in, first out processing, the report flags that, quote, a process should be established for designating especially critical cases in the backlog for review, such as individuals or families particularly at risk. This recommendation is incredibly critical. Many asylum seekers who are stuck in this backlog are refugees with absolutely valid cases whose families will, because of the backlogs, face difficulties or remain stranded in very dangerous situations for years while awaiting adjudication of the applicant's actual claim to asylum. For instance, we have clients whose cases have been stuck waiting in the backlogs even though their spouses and children are still stranded abroad. For example, in Syria, where they're in danger of persecution by the Assad regime, or in Nigeria, facing dangers from the Boko Haram. Some individual asylum offices have an informal short list or short notice list for attorneys or applicants, though most applicants who are unrepresented wouldn't know about this, to request to be called in if there are any interview slots that open up. But this is far from an actual process, and not all the offices have this kind of list. In addition, this informal process hasn't proven effective in many cases. For example, in one local asylum office where our lawyers work, there are dozens of asylum seekers on the short notice list, but only a handful have been interviewed in the last 6 months. It's critical for the asylum office, which is dealing with many urgent cases that have life and death consequences, to create a formal process for cases that need immediate or prompt interviews due to humanitarian considerations. Without such a process, the asylum adjudication system, particularly with the last in, first out process, is leading many refugees to be left in dangerous situations. Second, I'd like to agree on the critical importance of creating a process to handle applications for cancellation of removal. This has long been a problem. Fixing this gap in process would be a huge step forward. Your report outlines some solutions for creating processes for individuals to request and process cancellation of removal cases. Allowing USCIS to issue notices to appear in such cases and establishing a special unit to hear cancellation cases at USCIS would be effective approaches. I do, however, really want to caution against any approaches that essentially assume that individuals who apply for asylum years after arrival are simply seeking cancellation of removal and do not warrant asylum adjudications. We represent many asylum seekers who, for totally understandable and legitimate reasons, did not apply for asylum until many years after their arrival. Some have been subjected to a bifurcated process that the Asylum Division is now testing in a few locations. Having to come in for 2 formal interviews, once on the filing deadline and then again on the substance of the claim, is stressful and can be very traumatizing for applicants. It will also ultimately waste the asylum officer's time, since many of the same areas that go to asylum eligibility will inevitably also need to be discussed in accurately assessing whether the applicant is eligible for an exception to the asylum filing deadline. I'd also like to flag that the Asylum Office has a history of, at times, using the filing deadline to punt cases to the immigration courts. This was illustrated in some research conducted in the past by Professor Schrag and Pistone. At Human Rights First, we've taken on many cases that could or should have been granted by the Asylum Division, but were instead needlessly referred to the immigration courts. There are many applicants who could get ensnared in this bifurcated process and who end up who have to file late. We're going to see probably an increase in such cases potentially, with many people who potentially had TPS coverage for years, who may very well have valid asylum claims now, applying a number of years after being in this country. We also have many cases of people who fear persecution due to their sexual orientation or gender identity, who end up filing late for very understandable reasons. I should also flag that there are serious concerns that the asylum adjudicators at USCIS, as well as immigration judges at EOIR, may very well be feeling intense pressure to deny asylum cases in the wake of the repeated statements made by politically appointed agency leaders over the last year, painting asylum claims as lacking in merit. This is something that we need to monitor going forward. Third, I'd like to flag an important recommendation that's not included in this report, rolling back the expanded use of expedited removal. Through our pro bono program, we assist asylum seekers in locations across the country. The affirmative asylum system was largely functioning in a timely manner until the decision to expand the use of expedited removal and apply it to families seeking U.S. refugee protection. Of course, other factors are also at play, including the increase in asylum applications. Expedited removal was used only initially at ports of entry. The government is not required to use it more broadly. It is rather an option. Little by little over the years, however, the Department of Homeland Security expanded its use of expedited removal between ports of entry, but there was never sufficient attention paid or resources allocated to the conduct of the protection component of expedited removal. When the Obama administration decided to use it against families seeking asylum, asylum officers were diverted from conducting affirmative interviews, and we very quickly saw the increase in wait times for asylum interviews. One of the most effective steps DHS could take to cut the backlog is to roll back the use of expanded expedited removal between ports of entry and with respect to families seeking U.S. refugee protection. This move makes particular sense given at this point in time this blunt enforcement tool is being used against a population that is largely seeking refugee protection. The MPI report recommends a few strategies relating to expedited removal, including to allow asylum officers to initially adjudicate asylum claims. This was also a recommendation made, I believe, by the U.S. Commission on International Religious Freedom. The approach would need to be conducted in a way that ensures asylum seekers can secure legal counsel, have time to gather evidence necessary to support their cases, and are not held in immigration detention when they meet the release criteria. Finally, I'd like to touch for a few minutes on the defensive asylum system. There's not enough time for me to identify all the many challenges that asylum seekers are facing in it, but I will touch on just a few. The President's executive orders and administrative policies are having a devastating impact on both asylum seekers and the U.S. asylum system. First, the President has directed that he wants individuals to be held for the duration of their immigration proceedings, essentially regardless of whether they meet the criteria for release on bond or parole. We represent asylum seekers from a wide array of countries who, as a result, are being held in immigration jails across the country for many months, even though they meet the criteria for release. Alex touched briefly on the penalization of asylum seekers through detention, but also through the imposition of criminal prosecutions for illegal entry and re-entry. This is an increasing phenomena with more and more asylum seekers being prosecuted for their initial illegal entry under the zero tolerance policy. There was a lot of attention to this problem when this was being used against families, but that policy is continuing, and we've documented many cases of asylum seekers being criminally prosecuted for illegal entry under the zero tolerance policy and before it. Second, the report mentions the Attorney General's issuance of his decision in matter of AB, and Alex also touched on this. We are, in fact, seeing many individuals being initially denied asylum, despite the fact that the decision of the Attorney General, the actual decision as opposed to the dicta of the case, was actually quite narrow. We've already seen judges prejudging domestic violence cases and denying them as precluded by AB. For example, in one of our pro bono cases, an immigration judge explained that she would have granted asylum but for matter of AB. Another judge refused to take testimony on a domestic violence claim and denied the claim without a hearing. This is a challenge now across the country for women who have fled from severe domestic violence. Third, we've had deep concerns about the impact of many of the Attorney General policies on the fairness and effectiveness of the immigration courts. We don't have enough time to go into all of those policies, but just a few I'll mention. The Attorney General's statements, often directly to the immigration court leadership or to immigration judges, characterizing asylum cases as lacking in merit. Performance metrics and other moves aimed at rushing cases through the system. We are concerned that we are seeing many valid asylum cases denied protection by the United States. I'd also note you may remember what happened when Attorney General Ashcroft tried to get through the immigration court backlog by rushing cases through the system. The result was simply to shift cases to other parts of the system. Ultimately, this kind of approach is counterproductive, both to the system and to the impacted asylum seekers. there's so much more to talk about. I look forward to the Q&A, and I want to thank MPI again for including me in this presentation.
Well, Eleanor, thank you very much. You've been just an enormously valuable resource on all of this, and I particularly appreciate your drawing out in your comments some of these issues around cancellation of removal, because that illustrates so well what the difficulty is of just solving that problem. It's a many-sided dilemma. We're ready now to go to the Q&A part of our time, so the floor is open. I invite people to use the Q&A function on their screen or email events@migrationpolicy.org. You may also tweet to @migrationpolicy, #MPI-discuss. I have a couple of questions that have already been sent in, and I'm going to start with one that, Alex, I think probably you're best positioned to answer. Here's the question. Isn't it important to address both the U.S. asylum processing and also to do our part through refugee resettlement to respond to the global refugee crisis through resettlement? What operational or policy changes would be required to address both? And I think we know that it's not necessarily that we can't address both, but that this administration has decided to create a trade-off between the two. Alex, why don't you comment on that?
Yeah, right. People come into the country as refugees two ways: one, through our overseas program, and two, by applying for asylum and being granted asylum. I don't think there's a trade-off between those two routes in. But what's happened, of course, in the U.S. system is the Trump administration has dramatically reduced the number of refugees from overseas. Obama had set a final goal of 110,000. We're way under 25,000 with this year, with probably not any more than that. Next year, at a time of the highest number of refugees around the world since World War II. So we're going the wrong way on the resettlement side. That really is a presidential decision. Under the law, the president is entitled to, in consultation with Congress, to set the number of resettlement slots every year. I think those numbers, personally, I think those numbers are too low, and that the U.S. could absorb more. And there are all sorts of justifications for the U.S. doing so. I don't think that increasing refugee numbers will have much of an impact on the flow of asylum seekers coming to the U.S. They come from, the refugee program resettles people from the far-flung countries. The asylum seekers tend to come from closer countries in the region, but both a functioning and healthy asylum system and a healthy and functioning refugee system would be part of an appropriate refugee strategy for the United States. We seem to have neither at the moment.
Okay, another question here is directed to me, actually. It says, recently President Trump mentioned in the plenary at the United Nations that immigration issues are private issues from each country and not global. What do we think about that? Is immigration to do with nation-state sovereignty or an international issue? Well, I think I would certainly say, and Alex, I'd invite you and Eleanor, anybody to pipe in, absolutely refugee issues are international issues. They're issues of international cooperation, and they have to do with international agreements and norms. In particular, the issue that we're facing in the United States right now that animates this report has to do with not with the regional issue, which of course is part of the international system, but it's particularly pressing in that this is our neighborhood. These are countries that are nearby, and they're countries with which we've had deep entanglements over the years. They're countries that have strong, that have communities in the United States, strong communities of nationals from these countries. So absolutely, the answers and the awareness of how to move forward has to take into account an international focus and cross-national cooperation and effort. So the whole idea of that the President put forward at the United Nations this week, I think, from the standpoint of immigration and asylum, is something that I would strongly disagree with. Alex, do you want to add anything to that, or Eleanor?
No, thanks. That's fine.
Yeah, I'm happy to just jump in, and I wanted to just note from the prior question that the United States definitely has the capacity to both address the asylum backlog and to have a strong refugee resettlement program. National security experts who've served under both Republican and Democratic administrations have warned that our abdication of leadership on refugees actually hurts U.S. national security interests in many ways. In terms of international conventions and norms on refugees and migration, relating to refugees and migration, I note that the United States actually helped to draft the Refugee Convention, played a lead role in doing that. And the reason was that those international conventions help to promote global stability and protect U.S. interests.
Okay, I have another question here on the legal grounds for zero tolerance, especially the grounds for criminal prosecution of people seeking asylum. Alex, do you want to take a stab at that?
I didn't quite get the question. Can you say it again, Doris?
The question is, can someone please explain the legal grounds for zero tolerance as a policy, especially the grounds for criminal prosecution of people seeking asylum? How widespread?
Yeah. Okay. So, yeah, the legal ground is people entering the country illegally can be criminally prosecuted for doing so. Now, that really there's not been a widespread practice of doing that historically, except for people who have entered illegally, been ordered deported, and then seek to return, even though they've been ordered deported, occasionally be criminally prosecuted. What the Attorney General announces is a zero tolerance policy, meaning anybody caught entering illegally at the border would be put into the criminal process and prosecuted. Now, supposedly people who have good asylum claims should not be in that queue. They should be taken out of the prosecution because they are entitled to apply for asylum once they get to the U.S. border and should be protected. And Eleanor mentioned this, that these criminal prosecutions are pretty much flatly contradict the international convention here about not penalizing people who come and request asylum. So it should not be applied to people who have bona fide asylum claims and pass a credible fear test. And the government was trying to sort those people out to some extent. Other times people were pleading guilty and then being asked about asylum. It's been not a consistent practice at the border. But clearly people with good asylum claims should not be prosecuted for illegal entering. We accept the idea that many people applying for asylum here will not come with good papers. They're fleeing countries and they're fleeing danger. They're not going to be able to go into the U.S. embassy and get a visa to come to the U.S.
Okay, Eleanor, we have a question here on legal counsel and the importance of representation in asylum cases. And the question is, what can the government do, or the government to be of a mind to do so, to help in providing representation and really lay out what are the significant differences that we see in outcomes of cases as between represented and unrepresented?
So people who are represented, and we're talking about asylum seekers now, but asylum seekers who are represented are much, much more likely to succeed on the merits of their cases if they're legally represented. And that's, for many reasons, including the extensive amount of evidence and the complexity of legal arguments that have to be made. It's a very difficult system for people to navigate without legal representation. There is a lot that the government should be doing and could be doing more of to facilitate legal representation. I mean, first and foremost, it should not be, detaining people who don't need to be detained, because those who are held in immigration detention facilities are much less likely to be able to actually get legal counsel. I think something like, only 15 or 18% of people held in immigration detention actually have lawyers to represent them in their proceedings. It's shocking. And the government keeps, DHS keeps building immigration detention centers and opening them in areas that are far from cities where there is legal representation. So that's crucial for people not to be detained unnecessarily, and for when detention is used, which by and large it's not necessary given the alternatives, those facilities be in areas near legal counsel. There was an effort last year many people heard about to try to curtail the legal orientation program, which Congress has supported. It's enjoyed bipartisan support. It's a critically important way for people to at least get a little bit of legal information when they're held in detention. But the government should be doing more to fund legal representation. There have been multiple studies confirming that representation actually saves the government money in the end, leads to a much more effective and efficient process. So the government should be stepping up its support for legal representation instead of looking to do the opposite.
Okay, Faye, I think this is a question that perhaps you're closest to. Has there been an increase of denial rates of asylum applications, both affirmative and defensive, since this administration came into office?
It's a little bit too early to tell. I think most of the changes will occur as a result of the new guidance. The credible fear screen-in rate has stayed at about the same. I believe the approval rate in USCIS has stayed pretty steady, has maybe declined a little bit over the past couple of years. And in the immigration courts, I'm not actually sure, but I would expect the numbers have been pretty consistent over the past 5 years or so, and so I wouldn't expect too much change, but it's to be seen whether the guidance has impact on those rates in the future.
Eleanor, do you have anything you would like to add to that?
I would say that we are concerned about some of the dips in grant rates, and very concerned as well about the rhetoric of the political leaders who oversee the agencies that are actually entrusted with the adjudication of asylum claims. For Attorney General Sessions to go and visit the immigration courts or immigration judges and paint asylum cases as lacking in merit really is improperly signaling to immigration judges and to asylum officers that they're expected to not be granting these cases. So that's a huge problem. I believe TRAC has released some recent data as well, flagging decreases in credible fear review rates by immigration judges, and I think also declines in grant rates by immigration judges. So we're very concerned that about what we may be seeing in the asylum system, and really would encourage vigilance on this.
Okay, Eleanor, I have another question that I think would best be positioned to answer, and that has to do with language access for asylum applicants. How are language issues handled in the asylum process at the present time, and how well is it done, and what are issues that surround that?
There's a whole host of serious language issues in the asylum system at many, many parts. Translation, even by phone, is often not used in situations where it should be used. The quality of interpretation is often deficient. And for people who speak unusual languages in particular, sometimes the government does not succeed in actually even securing the appropriate interpreter. Now, this is a huge problem that affects many asylum seekers, and it's definitely an area that needs fast improvement and at a bunch of different levels.
Okay. Alex, here's a question that you should take. Do you think that the immigration system in the United States will affect the situation and systems in Europe and vice versa? In other words, how much, how much resonance is there between what's going on in the United States and Europe mutually?
I think both sides watch each other. They're significantly different systems for lots of complicated reasons that it's hard to borrow particular procedures back and forth. One way that it was moving forward was on the norms of recognizing these domestic violence claims, which started elsewhere and came to the United States through a concerted effort of advocates, which now Sessions seems to have tried to squash. But I think the real connection here is not so much at the technical grounds, but on the rhetoric. I just think that the president's rhetoric, the administration's rhetoric on asylum seekers and security risks and the crime that is brought supposedly by undocumented immigrants and asylum seekers, that clearly is reflected in Europe and the United States, and that's a kind of rhetoric that builds. It's led to electoral successes in Austria and Italy and Sweden and elsewhere that I think are directly related to what we see on this side of the Atlantic as well. And I think that's the most serious kind of borrowing back and forth, and that's going to take some hard work to wind back down.
Thank you. We have time for one final question, and it is, you've done the very major macro here, Alex, in terms of the world picture on this. Let me take it down to a very specific numbers question, and that it has to do with immigration judges being increased by about 50%. And then the question is, has there been a similar effort made to increase the number of USCIS caseworkers? And the answer is yes, that is actually the case, and we'll take you to the report to give you the numbers specifically. But there was quite a period of flat, no increases in funding at the Asylum Division in about 2009, 10, 11. But since 2012, it's picked up, and there really are quite significant resources in the last 4 years or so that have gone into the Asylum Division and asylum officers. And it's part of why it's possible for us to have made the recommendations that we have made about the ability to manage those resources and the need, the real imperative to manage those resources to their best effect, given the issues that we face in trying to get this system on a better footing. So with that, I need to bring us to a close. Absolutely want to thank the audience for being with us today. I do apologize. There are one or two questions that we weren't able to get to, but we got to as many as we could. I want to encourage you to look at our website for resources that are related to the issues that we've been talking about today. The slides and the audio from this webinar will be available at www.migrationpolicy.org/events. And let me remind you again that the report we've discussed today is called the U.S. Asylum System in Crisis, Charting a Way Forward. The co-authors are Doris Meissner, Faye Hipsman, and Alex Aleinikoff. It's available now on our website at the address that is on your screen. If there are any reporters on the call who have further questions, could you please call our Director of Communications, Michelle Mittelstadt? That number is 202-266-1910. With that, I will say goodbye and thank you again.